Welcome everyone to this lunchtime webinar on non-compete clauses in employment contracts. Our speakers today are Senior Legal Associate Jasmine Yek from Concilium Law Corporation, followed by Ms. Lim Shenen, a Legal Associate also from Concilium Law Corporation. So I'll hand over to you now, Jasmine. Thank you.
Thank you, Catherine. Welcome everyone. Good afternoon to all of you. I would like to thank my managing partner, Mrs. Franca Shambella, for giving us the opportunity to speak today. And I'd also like to thank my co-speaker, Ms. Lim Shannon, for her hard work, her excellent work on this webinar. I would also like to thank Catherine and Margaret, my colleagues, for their invaluable behind-the-scenes work on this webinar. And finally, but not the least, I'd like to thank all of you for taking time out of your precious schedule and busy schedule to attend this lunchtime webinar. Just some brief information on Concilium Law Corporation. We are a Singapore law firm. We specialize in corporate and commercial law, family law, civil and commercial disputes, employment law, wills and guardianship, mediation, and fintech. Please feel free to reach out to us if you have any legal queries. We'll be very happy to assist you. All right, please note that the contents of this webinar is not legal advice, but it's just on the law in Singapore in general. Some brief information about me. I'm a Senior Legal Associate at Concilium Law Corporation. I graduated from the National University of Singapore in 2006, and my practice areas are predominantly in corporate and commercial law and civil and commercial disputes. However, I have a wide range of experience in other practice areas, and I'm able to provide background to these matters if you have any queries. And now I'll just let Shannon introduce herself. Shannon, please.
Thank you very much, Jasmine. Just to introduce myself, my name is Shannon. I'm an legal associate with Concilium Law. I obtained my Bachelor of Laws from the Singapore Management University in 2017, and I was admitted to the Singapore Bar in 2018. So my principal areas of practice lie in corporate and commercial law, as well as employment law. And I also have some experience advising on family law, as well as probate and estate matters. Thank you, Jasmine.
Thank you, Shannon. All right, without further ado, let's dive in with an introduction of what we are going to cover today. Firstly, we will cover what is a non-compete clause. A non-compete clause, in a nutshell, as our seminar title states, is one that is reasonable between the parties and reasonable in the public interest. Being reasonable between the parties means that the clause must protect a legitimate proprietary interest belonging to the employer and not be too wide in terms of scope, geographical limitation, and period of limitation. We will also touch on remedies for breaching a non-compete clause, and also at the end of this webinar, we will talk briefly on a summary of the things covered in this webinar. Many of you may already know what a non-compete clause is. Essentially, a non-compete clause restrains the employee from carrying out his employment or trade. The case on point is Constant Nordenfeld versus the Maxim Nordenfeld Guns and Ammunition Code, which states that everyone has an interest in carrying on his or her trade freely. All restraints of trade are, without anything more, contrary to public policy and are void. However, restraints of trade will be allowed if they are reasonable. And this is back to the first 2 points, whether it is reasonable in the interest of the parties and whether it is reasonable with reference to the interest of the public. At this point, I would like to take a brief look at the case of Blackwinoy versus Humming Flowers and Gifts Private Limited, which was decided by the Honorable Justice Vinod Kumaraswamy. As he stated in paragraph 33 of this judgment, there are two competing policies with regard to restrictive covenants. One is that this is a policy of upholding contractual bargains which parties of full age and sound mind freely enter into. And the second is the policy of protecting a person's fundamental liberty to earn a living and to do what he chooses. Also in this case, the Honorable Justice Kumaraswamy went on to note that there's a distinction between non-compete clauses in employment contracts and non-compete clauses in contracts for sale of business. In this sense, he said that the law is stricter when it comes to restrictive covenants found in employment contracts. And he gave 5 reasons as stated in Hayden, the Restraint of Trade Doctrine, for this stricter view. And of course, I shall just briefly summarize them. Firstly, employees tend to lack bargaining power as against employers. Secondly, an employee's ability to sell his labor may be his only asset, whereas a vendor will have capital in hand from the sale of his business and is better able to sustain himself. Thirdly, why the law is stricter when it comes to restrictive covenants in employment contracts. A business will often be valueless to a purchaser without the vendor's covenant not to compete. In contrast, an employee provides value through his services during the course of his employment, whether or not he later competes against his employer. Fourthly, once an employee accepts a restrictive covenant, his employer's bargaining position during the employment is much increased because the employee's ability to withdraw his services and seek work elsewhere is inhibited. And finally, it is in the public interest for employees to be free to move towards jobs in which they can most effectively use their skills. Restricting this freedom distorts the labor market and diminishes its ability to move employees to where they will do the most good. So in summary, the Honourable Justice Kurunraswamy stated that the fundamental and threshold question will be whether there is a legitimate interest to be protected. He also stated that proprietary interests acquired in a sale and purchase transaction of assets and business, including goodwill, is legitimate interest that it can protect through non-compete clauses with the employees by way of their employment contracts. Next, I will go to touch on reasonableness between the parties. This is actually assessed at the time of making the contract, bearing in mind the circumstances that the parties reasonably contemplated at the time they entered into the contract. If the employer is relying on the clause, he has to prove that the clause is reasonable. The clause must also protect a legitimate proprietary interest, which would be things like trade secrets, highly confidential information, customers, and employees. If this interest is already protected by another clause, there might not remain any legitimate proprietary interest to be covered by the non-compete clause. And if so, the clause is void and unenforceable because it will be taken that its objective would be to inhibit competition. Moving on, legitimate proprietary interests will exclude skills, experience, know-how, or general knowledge. And we will just briefly touch on the case of Stratec Systems Limited versus Niam Chiu Shin, which is a 2005 Court of Appeal case affirmed in the Court of Appeal case of Man Financial Singapore Private Limited versus Wong Bat Chuan David. In this case, it was stated that the protection of one legitimate proprietary interest, which in that case was confidentiality, has already been covered by another clause in the contract. The non-compete clause must cover a legitimate proprietary interest over and above that which was already protected. So this case is of note because in 2013, Honourable Justice Wubili in the High Court case of Centre for Creative Leadership, CCL Private Limited versus Byrne Roger Peter made the following observations, that there are some English cases which recognize that a non-compete clause can also protect trade secrets and confidential information, even though there is already a confidentiality clause in that contract of employment. And in the 2014 case of Blackwinoy, which we have addressed earlier, Honourable Justice Kurunraswamy was apparently of a similar view, as he held at paragraph 71 of that judgment that he had sympathy for the concerns expressed by Wu Jie, and he also allowed the defendant in that case leave to appeal to the Court of Appeal because of this issue. However, the defendant did not appeal to the Court of Appeal on that case, which left Honourable Justice Wubili J in a High Court case of Power Drive Private Limited, a 2019 case decided on 10 October. It was reported in 2019, but it was decided on 10 October 2018. That he made an observation again that considering the English cases, the Court of Appeal may wish to review its decision in Stratec Systems. This case was actually followed in Stratec Systems was followed in HT SRL versus Wee Shua Boon, a 2019 case decided on 18th April 2019 and remains the law in Singapore today because in Singapore, under the doctrine of stare decisis, the High Court, District Courts and Magistrate Courts are bound by decisions of the Court of Appeal unless the lower court can distinguish the earlier case based on the material facts of the case. However, we also note that Justice Kuraswamy, in the 2014 case that he decided, he actually quoted Centre for Creative Leadership and stated, "Indeed, one may add that it seems illogical that an employer who does not have the benefit of a confidentiality provision in his employee's contract of employment has a better chance of establishing confidential information as a legitimate interest to protect under a non-competition clause than an employer who has sought to protect his confidential information by the use of dual provisions, i.e., one specifically to preclude disclosure of such information post-employment, and the other to restrict the employee from engaging in a competitive business of a certain duration and within a certain geographical scope." And in Centre for Creative Leadership, Justice Wubili had observed that confidentiality obligations are difficult to police, and therefore in certain cases, the best practical solution would be to use a restrictive covenant in addition to a confidentiality clause. Moving on, these are the 3 English cases that were mentioned in Centre for Creative Leadership. Just to summarize them very briefly, in the Littlewoods Organization versus Harris, the defendant was a former director of the plaintiff company, and he had a provision in his employment contract stating that he could not be directly or indirectly engaged in a business of a competitor for 12 months after the termination of his contract. There was a confidentiality clause in his contract. Lord Denning, Master of the Rolls, a very famous judge, held that the non-compete clause protected a legitimate interest of the plaintiff, being confidential information, and he stated that it is established that an employer can stipulate for protection against having his confidential information passed on to a rival in trade. But experience has shown that it is not satisfactory to simply have a covenant against disclosing confidential information. The reason is because it is so difficult to draw the line between information which is confidential and information which is not, and it's very difficult to prove a breach when the information is of such a character that a servant can carry it away in his head. The difficulties are such that the only practical solution would be to take a covenant from the servant by which he is not to go to work for a rival in trade. This case of Littlewoods was followed in Turner versus Commonwealth and also in Thomas and Farr. And in both Turner and Thomas and Farr versus Farr, it was held that there are serious difficulties in identifying precisely what is or what is not confidential information, and who may or may not have been a customer during the period of an employee's service. And therefore, a restraint against competing, which is reasonable in time and space, will be possible, but also will be the most satisfactory form of restraint. So this matter, as we have looked at Stratec today, has been observed that it may be for the Court of Appeal to actually revise and relook at the law in this area. And from this point, I will also hand the time over to Shannon to continue the rest of this presentation. Thank you so much for your attention up to now.
Thank you very much, Jasmine. So another one of the categories of a legitimate proprietary interest, which a non-compete clause may actually intend to protect, is actually that of customers. In order for the restraint to be reasonable, it's generally well established that the employer must have personal knowledge of and influence over the customers of the employer for the employer to claim that a non-compete clause is necessary to protect trade connection. This was also mentioned by the courts in the case of Man Financial. And while the extent of the knowledge of and influence over the customer is a relevant fact, knowledge is actually immaterial unless it can and is likely to be leveraged in some way by the employee to gain some degree of influence. There are several factors which may be relevant to the question of influence. For example, the frequency of the contact with the customer, the place where contacts are made, the seniority of the employee in question, the nature of the employee's relationship with the customer, and the nature of the goods and services provided. It's not enough for the employee to simply have contact with the customers or to have access to a list of customers. There must be some element in the employee-customer relationship which actually causes the customer to rely on the employee and to regard the employees as the business to the exclusion of the employer. The restraint may also extend to prospective customers who are in negotiations with the employer. A clause restraining doing business or dealing with former customers would also restrict the employee even if he was being approached by the customer. The clause may also restrain an employee. A clause may also restrain an employee from soliciting customers which he had actually brought with him when he joined the employer. Another category of which the clause could be intended to protect would be that of employees. Non-solicitation clauses prohibiting the poaching of an employer's other employees are by now actually fairly common and are actually vital in industries which are increasingly dependent on the accumulated knowledge and connections of their employees in order to function as a commercial entity. So in the case of Man Financial, one of the issues raised was whether the employer actually had a legitimate interest in maintaining a stable and trained workforce, such that they could actually restrain an ex-employee from poaching other employees via a restraint of trade clause to that effect. With respect to the non-solicitation clause, the court in that case actually found that the appellant had a legitimate proprietary interest in maintaining a stable and trained workforce, given the nature of their business. They were in the business of providing financial services, more specifically brokerage services, the position and influence of the employee, and the confidential information possessed by the employee regarding the relationship between other employees and the employer. A further legitimate proprietary interest, which a clause could be intended to protect, could be that of suppliers. So this may be established if the employee has dealings with the suppliers, and especially if the suppliers are from a small and specialized industry. Of course, the categories of legitimate proprietary interests are non-exhaustive, and it will depend, you have to prove it based on the facts of the case. For a restrictive covenant also not to fall foul of the restraint of trade doctrine, it is insufficient for it to simply fulfill the criteria of covering a legitimate proprietary interest. The covenant must, in addition, also fulfill the twin criteria of reasonableness, in that it goes no further than necessary to protect both the private as well as the public interests. In terms of being reasonable between the parties at the time of making the contract, it must not be wider than necessary in terms of scope, geographical restriction, and the period of limitation. In terms of not being wider than necessary in terms of scope, if the employee actually worked in a specific part of the employer's business, the non-compete clause will be void and unenforceable if it extends to the entire business or to the entire industry. For example, in the case of Bachman Laboratories, the plaintiff in that case had business interests in multiple industries, whereas the defendant employee was only employed in the pulp and paper industry. In that case, the restraint was extended to all of the industries that the plaintiff employer was actually involved in, and the courts actually deemed this to be too wide. We'll also have to consider whether it is reasonable to extend protection to other companies in the same group of companies as the employer. It may be too wide if it extends to customers and suppliers that the employer has not dealt with. In the case of Man Financial, the courts remarked that, in their view, the scope, or more accurately, the categories of employees covered under a non-solicitation clause goes to the reasonableness of the clause concerned, which in turn actually depends on the precise factual matrix concerned. Although the concept of a trained workforce is arguably a broad one that ought to be construed in the context of the particular factual matrix in question, generally speaking, the court remarked that if the non-solicitation clause concern covers employees whose work entails very minimal or even no expertise and does not form an integral part of the employer's operations, it would, absent extraordinary circumstances, be extremely difficult for the employer to justify the reasonableness of that particular clause. However, everything in its final analysis depends on the particular factual matrix. Further, the clause should also not be wider than necessary in terms of geographical restriction. The clause cannot cover more countries than which the employees had dealings. In the case of Tan Kok Yeong Steve and the Teochew Singapore Private Limited, in that case, they actually, the learned judge, Judith Prakash, as she then was, cited Buckman Laboratories, whereby it was held that a reasonable restrictive covenant would have limited the restriction to countries in which the employee had actual and significant customer contacts. On the facts of Buckman, the geographical scope of the restrictive covenant actually included countries where the defendant employee had never done any work and was never exposed to any of the customers. So this was actually one of the factors for Justice Prakash holding that the restrictive covenant was an unreasonable restraint of trade. At the end of the day, the issue of reasonableness on the geographical coverage will depend on the specific facts of each case. A worldwide restriction may be treated as being unreasonable. If a restraint of trade clause does not actually state the area of limitation, the implication may be that it's a worldwide restraint, which will actually render it unreasonable for the clause to be upheld. However, based on existing decisions, it appears that whether a worldwide restraint is actually reasonable would depend very much on the specific facts of the case. In the case of CCL, which was cited by my colleague Jasmine earlier, while the clause in the case was actually rejected due to the fact that the geographical scope of the non-compete clause was too wide to be reasonable, the courts did not appear to outrightly reject the possibility of a worldwide restraint clause under reasonable circumstances. It is thus possible that a Singapore court could be open to such circumstances where it is justifiable to restrain an employee from competing across the globe. Moving on, in terms of the period of limitation, the clause must not be wider than necessary in terms of the temporal scope or the period of limitation. And reasonableness would depend, for example, on whether the industry is specialized, the advantage a competitor would have if provided with the employer's confidential information, and the time taken to establish a relationship with a customer or supplier. So in the case of American Lee Asia Private Limited and Key Fu Ming, Laurel and others, an employer that was involved in the sale and purchase of electronic components sought to actually restrain its employee from engaging in competition with the employer for a period of 1 year after employment. The court found that the restraint of 1 year was actually unreasonably long in that case. This was based on the court's finding that the pricing of electronic components was actually volatile. And to quote the court, as there are thousands, perhaps countless electronic components in the market, it is thought impossible for anyone to deal in all of the components in the market all of the time. Indeed, it is a well-known fact too that the shelf life of electronic components tend to be rather short, constantly being replaced by newer and technically better components. In the case of Tan Kok Yeong Steve and Teochew, the defendant's counsel argued that the 2-year restriction imposed was necessary because it takes time to actually build up customer connection in the cement products industry, which the employer in that case was involved in. They pointed out that the plaintiff took about 4 years to actually build up his customer connections, and the defendant employer would require at least 2 years to actually allow the plaintiff's replacement to actually try to rebuild those same contacts without any interference from the plaintiff. The court accepted that, indeed, if the plaintiff was not actually prohibited from dealing in these products which he had become familiar with, it would be difficult for a newcomer in the market to actually build up his own customer connections. The learned judge in that case also noted that the present case involved the trading of cement products, which is also a specialized industry. However, it should be noted that at the end of the day, the reasonableness of a non-compete clause in terms of its period of limitation or temporal scope will also depend on the specific facts of the case. The second aspect of the reasonableness test is that the non-compete clause should be reasonable with regards to the public interest. The clause is against public interest if it leads, for example, to the employer having a monopoly. The employee has the burden of proof to actually establish this. In the case of Mine Financial, whereby the learned judge in that case cited the example of the case of Thomas Cohen, in that case, the plaintiff employer had actually brought an action against its former employee to restrain him from continuing to commit a breach of covenant relating to the plaintiff's fumigation business. In that particular case, the relevant covenant actually stated that on the defendant employee, on leaving the services of the employer, for any reason whatsoever, either pursuant to the agreement or in the event of a breach, shall not carry on the business of white-end exterminator or fumigator, which is the plaintiff's business, anywhere in the island of Singapore, either by himself or in partnership with others, nor shall he take on any employment with someone carrying out similar business for a period of 3 years. The defendant later actually left the plaintiff's service and became a director in a rival company, whereupon the plaintiff actually brought an action to restrain the defendant from breaching the above covenant. In this case, the plaintiff employers were the only fumigators in Singapore at the time, and even though the clause was reasonable between the parties, the courts did not actually enforce it on the grounds that if the defendant is not allowed to operate the plaintiffs will actually have a virtual monopoly in Singapore as regards the fumigation by hydrogen cyanide and methyl bromide. So in fact, prior to the defendant's firm coming into existence, the plaintiffs were the only firm in Singapore doing fumigation. And since the defendant's firm actually came in competition, the charges for ship fumigation had actually dropped, which is a good thing. And there was no evidence that the standard of fumigation on ships had actually deteriorated. Hence, it's interesting to note that while the judge had actually first held that the covenant was reasonable as between the parties, he proceeded to consider separately the public interest involved and found that the covenant was unreasonable insofar as the interest of the public was actually concerned. Furthermore, the doctrine of severance can also apply to a non-compete clause. In the event that a clause is found to be unreasonable, the clause may actually be partially enforced by severing the part that is too wide. So the Court of Appeal in Man Financial held that in applying the doctrine of severance to a restraint of trade clause, the court must be able to run a blue pencil through the offending words without actually altering the meaning of the provision, and of course, without rendering it senseless, whether in a grammatical sense or otherwise. So the courts will not actually rewrite the contract for the parties. Importantly, the character of the contract must not be changed. No words may be altered or added, and the clause must remain grammatically correct. In the case of Buckman Laboratories, there was a modification clause which provided that in the event that any such restriction shall be found to be void, if it would be valid if some part thereof were deleted, or the period of application reduced such restriction, shall apply with such modifications as necessary to make them valid or effective. In that particular case, the learned Justice Judith Prakash remarked that to allow such clauses would actually lead to uncertainty, as an employee would have no means of knowing the extent of his obligations and would be in an invidious or unfair position regarding his future employment if he ever sought to leave the employer. So this was actually quoted with approval in the case of Man Financial. There's also an additional consideration to note, which is that an employer's fundamental or repudiatory breach of the contract may actually make the non-compete clause unenforceable. In the case of, for example, General Bill Posting Company Limited in Atkinson, this was a case of whereby the employer had actually wrongfully dismissed an employee without the requisite notice period. The employee was thus entitled to treat the dismissal as a repudiation of the contract, sue for damages for breach, and was also no longer bound by the covenant on restriction of trade. Moving on, in terms of remedies, for the employers, the remedy for the breach of a non-compete clause lies in damages. This can include damages for breach of contract, for example, a loss of profits in the event that customers are lost, or an account for profits if the employee is a fiduciary. Another remedy would be an injunction to actually stop the employee from carrying out his trade. There could also be a possible claim against the new employer if it can be shown that he had actually induced the employee to breach his contract or actually obtain information from the employee in breach of the employee's duty of confidence. For employees, an employee can also seek a preemptive declaration from the court that the non-compete clause is actually void and unenforceable. So in summary, in terms of the burden of proof, the employer has to prove that the non-compete clause is reasonable. The non-compete clause must also protect the employer's legitimate proprietary interests and cannot be wider in scope than what is necessary. In terms of the burden of proof, for the employee, they will have to prove that the non-compete clause is against public interest. An employer can also seek damages or an injunction against the employee, or even claim against a new employer in certain circumstances. So thank you very much. We have actually come to the end of our brief presentation today. We appreciate you taking the time to listen to us. Please let us know if you have any questions. Alternatively, we have left our contact information here. You can either contact one of us, Franca is our Managing Director, or Jasmine or myself, and we will be happy to get in touch with you directly and speak with you on any questions that you might have. Thank you very much.
Thank you very much, ladies. And thank you everyone for joining us today. Hope you have a good weekend ahead.